welcome to my market update. Today I invited Kendall Vanconis of A to Z Law to sit in with us and answer some of the probate questions that we come across occasionally when people wonder whether or not they have to go through the probate process. I know, Kendall, you've been doing that 25 years in the estate law realm, is that right?
That's right.
Okay. So maybe just to get into some of the common questions, that we won't probably cover everything, but maybe some of the common questions. Number one is, well, why is probate needed, or why is it required?
Probate is one of the ways, and it's unfortunately the court supervised way of transferring assets of people after they pass away.
Okay.
There's a variety of ways that transfer can occur, and probate occurs in a court setting, most typically when people pass away without any kind of will in place.
All right, so they didn't have anything set up, and obviously then it requires the court process. So what are some of the challenges that you see in that process that you come across, and pitfalls, things like that come up?
Probate gets a bad rap for a few main things. Mainly, it can take a long time. It can take a longer time than it needs to. The probate code has a minimum period of 4 months that has to go by from beginning to end.
Okay.
And it commonly takes far longer than that. 6 to 10 months is not uncommon for a probate administration. So that's one of the main reasons people don't like it. The other one is cost. Fees for the probate are also set by law, and so it can frequently cost more than it might otherwise need to.
Okay.
And the last reason is anytime you're in court, you lose control of the process. You don't really ever know what's going to happen when something ends up in front of the judge.
Sure. And I would imagine sometimes even having beneficiaries and more beneficiaries can even complicate that process even more in terms of even, what happens, and then even the length of time. Is that right?
That's right. Everybody is entitled to notice. They're entitled to be there and appear at the various hearings. They're entitled to know what's going on every step of the way, and people will have their own opinions about how things should go.
Okay. So speaking of how it should go, what are some of the basic requirements of the probate then?
Well, to get started, as anything that goes to court, there's of course a bunch of paperwork that has to get prepared and filed.
Right.
There's a filing fee just to get those papers past the window that's almost $500.
Okay.
There's a notice that has to be published in the paper. So everything is public. It's open to public record. People can appear. Of course, there's a cost for that publication. And then the initial hearing when the executor or administrator is appointed. And that whole process there can take 30 to 45 days just to get things open and started.
Okay. So you already covered on how it takes roughly 4 months, roughly.
There's a minimum of 4 months. It can't be any less than that.
Oh, is that right?
That's right.
Okay.
Yes.
So regardless of how fast that's the fast track then?
Yes, exactly.
Okay. So what typically adds time to that, if anything?
Usually things that are easily planned around. So for example, if somebody has real property and they die without a will, then the court has to approve the sale of that property. And again, that's a whole nother process. The notice periods run, that sort of thing. Sometimes problems can occur if a person passes away with debts and there's creditors' claims that have to be dealt with. Those all end up in front of the court, and those can take a long time. And then of course there's the thing that probably people fear the most, which is some kind of objection or contest. Somebody doesn't like the terms of the document, or they believe there's a document out there when maybe another person believes there isn't. So it's sort of those worst case family scenarios
I can see that,
end up in court.
All kinds of hallucinations that happen in that process. All right. So what your role in this process is? Just help facilitate? Is that primarily, or what other
Yes,
things?
the attorney's role is to sort of shepherd that process from beginning right through the date of distribution. So that's making sure that all of the court papers are properly drawn up and filed, that all the statutes are respected, so time periods that have to go by are respected. If there's any issues that arise with respect to creditors, tax issues can often be a problem. Any specialized services that we would assist our client in obtaining, for example, real estate services, lending services, if there's any specialized issues that the person was dealing with at the time of their passing, we help facilitate all of that for our client.
Okay. So obviously it's, time consuming and it's costly, basically is what you're saying with probate. So is it possible to avoid probate? And if so, what recommendations would you have for that?
Sometimes probate can be avoided because the situation is very simple and people don't need to do anything. For example, a very small estate. If somebody has modest assets, they can pass outside of probate entirely.
Oh, okay.
Marriage can actually be a way to avoid probate.
Okay.
Assets that are held as community property or jointly owned. The fear there is that a spouse might pass away within a short period of time of having just lost their spouse.
Oh, gotcha.
So that can still lead to probate. But the preferable way, and wearing my estate planning attorney hat,
Right.
the best way to avoid probate is to make a living trust.
Okay. Excellent. Well, so if people have more questions for you, what's the best way for them to reach out to contact you?
They're welcome at any time to call my office. We're in Oxnard,
Okay.
top of the Financial Plaza,
Excellent.
at 988-9886. And our website, atozlaw.com, has lots of information about the services we provide.
Excellent. Well, thanks again for joining us for our market update. If you have more questions about buying or selling, give me a call, 805-339-3516. Thanks.